Hello, precious viewers. Welcome once again to G. Festus Gwungmijana's legal discourse on law of trusts. In today's tutorial video, I shall proceed with my discussion on classification of trusts. This is 7th video on classification of trust, and heartwarmingly we are to consider the last classification today. After outlining the various classes, then we started considering some of them in a bit detail. So today is the last class of trusts that we are to consider in detail, and it is constructive trusts. So let's begin. In my video on the general overview, the first video on law of trusts, on classification of trusts, recall that I classified constructive trusts under a particular aid together with implied or resulting trust and expressed trust, and the aiding is according to how it arises or according to how they are created. That's what helps you to understand clearly what they entail. So I put them under a particular aiding that all these three classes of trust can be classified into a classification of trust according to how they arises or according to how they are created, because they are defined, their definition, their meaning is based on how they are created or how they arises. Now, how does constructive trust arise? What makes it similar with implied or resulting trust and express trust is because they can be classified according to how they arise. But the difference between them now is that express trust is created or arise from the expressed, as the name implies, expressed intention of the settlor. It arises from the intentional act of the settlor. So it arises from the actual intention of the settlor, while implied trusts arise from the presumed intention of the settlor. That intention is presumed by law with respect to implied trust. Now, constructive trust, how does it arise? Constructive trust arises by operation of law. It does not arise, it neither arises from the express intention of the settlor nor from its presumed intention. It does not arise from any of this way, but it is imposed. It is a trust that is imposed on a person or on the trustee by law. So it is the law that imposed this particular trust, constructive trust. It is the law that imposes it on a trustee. So constructive trust is imposed by law, is imposed by equity under certain circumstances. Essentially, when it will be unjustifiable, it will be unconscionable, it will be inequitable for a person to hold the beneficial interest for the person who has the legal title of a property to hold the beneficial interest. Then constructive trust will be imposed on the person when it will be unconscionable for a person to take the benefit of a property. When it will be unconscionable for a person to take a particular profit from a property, then the law we declare that person to be a trustee for a person who is actually entitled to the property, or for the beneficiary. So that's what constructive trust is all about. It is imposed. That's the operative word. That's the important word. Imposition. It is imposed by law on a person, and not by the express or presumed intention of the settlor. In fact, in this class of trust, there is no regard to the intention of the settlor, irrespective of the intention of the settlor. So I haven't tried to, you know, uh, explain it. Let's actually hear in appropriate terms, or more appropriately, what scholars and the courts have to say about constructive trusts. But let me just set one example to solidify my explanation. So if, for instance, now Long hold the legal title to a property, or is in possession, is in control of a particular property, or is occupying a particular position, and it will be inequitable or unjustifiable for Long to benefit, to take a particular profit, or to take the beneficial interest of that property, which God is entitled to. God is entitled to that property, but Long want to use his position to take beneficial interest of that property. What the law, what the court will do, the court will declare Long as a trustee for Young. So Long, for God rather, Long will be declared as a trustee for God, and the essence is that it will be made not to take the benefit of the property for himself, but to hold it on trusts for God. Also, it will be accountable to God. Maybe if you have taken any profit since, it will be accountable to God. And also, it will be entitled to transfer, God will be entitled to the property, and it will be compelled to transfer the property to God. That is how constructive trust operates. Now let's hear from scholars and the courts. First, according to Parkinson P, in Principles of Equity, second edition, this is how it defines a constructive trust. A constructive trust is a trust which is imposed by operation of law in circumstances where, according to equitable principles, it will be unconscionable for the legal owner of the property to retain beneficial interest in the property. So you can see that's what I've explained since. So all these definitions we shall be looking at, it will still be saying the same thing, which I've actually tried to explain since. Let's also hear from the court what the court stated about constructive trust in that case of Hubner versus aeronautical engineering, aeronautical industrial engineering and project managing company. What they said, in fact it is Supra, I believe we have mentioned it before, what the court say or stated or held about constructive trusts. This is what the court stated. The court stated that constructive trust is neither granted nor accepted by the neither accepted, but it is forced upon the parties by the operation of law. So constructive trust is forced upon the parties. So in constructive trust now, you will not see where a settlor is appointing a person as his trustee, or is declaring a person as the trustee of a particular property for another, you will not see such case, but it is the law that impose it on the parties. So it is neither granted, unlike express trust, where in some cases the settlor will grant will appoint by granting the appointment to a particular person, the trustee, and the trustee is entitled to accept or reject the appointment of a being a trustee. But in this case, the law imposes it on you, and you will have no option. There is a constructive trust. That's why in constructive trust, we have mentioned that there are three parties to a trust relationship: settlor, trustee, and beneficiary. But in constructive trust, at times now, in fact, in most of the situation, it will be difficult for you to identify if you want to, analyze the trust in terms of the parties. You may find it difficult to actually identify where is the settlor, who is now the settlor now in this trust. So there is a it is to me, I said that the law, equity, is usually the settlor in a constructive trust. Also, let's also hear from the court what the court stated about constructive trusts. In the case of BT versus Gwungmijana Exploration Company. In the case of BT versus Gwungmijana Exploration Company, let's see what the court said about constructive trust in that case. And the statement was made by, in fact, it was a definition or a description given by Cardozo J. Cardozo J defined or explained constructive trust as follows. A constructive trust is the formula through which the conscience of equity finds expression, where property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interests. Equity converts him into a trustee. You see, so where a person holding the legal title to the property is taking or is retaining the beneficial interest of that property, but he is not doing that in good conscience. It is not justifiable or equitable for him to do so, and is doing that to the detriment of the person who is actually entitled to the property, then equity will declare him to be a trustee. So it is the formula, the method through which the conscience of equity finds expression. More interestingly, let's hear what the court stated about the nature of constructive trust in the case of Ibekwe versus Nwosu. Ibekwe versus Nwosu. In this case, the court actually describe or give a various interesting name to other names to constructive trust. And this is what the court say. A constructive trust is an equitable remedy that a court imposes against one who has obtained property by wrongdoing. It is imposed to prevent unjust enrichment and creates not fiduciary relationship. It is, look at other names given by the court. It is also termed implied trusts, involuntary trusts, ex delicto trusts, ex maleficio trusts, remedial trusts, trust in victim, or trust de santos. Then the court further continue with what has been stated in the case of that BT, where they say it is a formula. So after saying all this, there's the next thing, there's the next continuation of the statement. That it is a formula through which the conscience of equity find expression where the holder of a beneficial title, of a legal title, will not retain the benefit in good conscience, or where it is unconscionable for him to do so. You can see beautiful description given to constructive trust in that case of Ibekwe versus Nwosu. So there's what constructive trust entails, and the simple idea is that whenever somebody is in a position that, and the person or is in control, is holding the legal title to a property. Constructive trust now does not only is not only concerned or related to where a person is holding a legal title to a property. It could be that a person is in a position and the person want to take undue advantage, unconscionable profit from that his position, or from a given property. The law will declare the person as a trustee for the person who is actually entitled to it. Do you think equity they do? You think that equity don't do too much in this regard by doing like busybody? Nobody sent him to declare someone as a trustee, but is doing so. Do you think that equity don't do? Well, to me, I think the circumstances in which equity will declare somebody as a trustee is actually justifiable and reasonable, because it is to prevent, just like the court say in Ibekwe versus Moses, is to prevent unjust enrichment. Next, let's look at scope or areas of application of constructive trust. So in what area, in what circumstance is constructive trust applied? When will a person be declared a constructive trustee? That's what this aid is saying. So what is the area of application? According to scholars, constructive trust has a very wide area of application. So there are many circumstances where constructive trust can be applied, where a person can rely on constructive trust, that a so person is a constructive trustee to him. So there are many areas. Essentially in America, it has a very wide area of application in America. So they have also observed that constructive trust has a very wide area of application in America, and it is regarded, considered, or treated as a remedy for unjust enrichment. So in any circumstance where somebody want to enrich himself unjustly to the detriment of the person who is actually entitled to that property, from which is taking the benefit or making the unjust enrichment, then the person will be declared a constructive trustee. So it has, take note that it has a wide area of application in America. Now in England, or under England law, it is applied in the following areas, in the following established areas. So we shall now consider the area it is applied in England and by extension Nigeria. The first one is, the first aid of application is that unauthorized profits by trustees and other fiduciaries. So there's one area of application of constructive trust. whenever there is an unauthorized, a profit that is not authorized is made, whenever a trustee is trying to make an unauthorized profit, or whenever a person in a fiduciary relationship or standing in a fiduciary position to another is trying to make unauthorized profit, then equity or the law will declare the person as a constructive trustee. So that's what this heading is all about. So under this heading now, whenever a trustee first, whenever a trustee or a person standing in a fiduciary relationship with another try to make profits from his position, or secret profits, then the person will be declared a trustee, a constructive trustee for the person who is actually entitled to the property. So whenever a trustee who is holding a property for the benefit of another, or a person in a fiduciary relationship. What is fiduciary? Fiduciary relationship, or a fiduciary is a person who is to act for the benefit of another. So a trustee is a fiduciary, or is a person who owes another the duty of good faith. He owes another the duty of confidence. So is obligated under the obligation of the law to act in good faith toward the other person, to act in confidence, not to betray the person confidence. So there's such person is a fiduciary. So what this heading is saying, that if you are a trustee or you are a fiduciary, you are standing in a fiduciary relationship with another person, and you are holding a property, or you are in such a position, a particular position, if you make any unauthorized or secret profits from the property, or from your position, then the law will declare you it is constructive trustee of any profits you make out of the property. That's what this heading entails. So this principle applies to trustee and other fiduciaries. It applies to trustees and other fiduciaries such as agents. So an agent is a person, is a fiduciary. He stands in a fiduciary relationship between is in a fiduciary position between him and his principal. Then other example is partners. So this trust can be applied to partners and promoters, company promoters or directors. They are fiduciaries. So if they try to make any profit unauthorized, if the profit is not authorized or is a secret profit, the law will declare them a trustee of that profit for the benefit of the trustee or any person of the beneficiary, or any person entitled to it. So this principle was applied in there's example cases, illustrative case where this principle was applied. But let's look at the statement of Lord Herschel in Bray versus in Brave versus Ford, Lord Ashiel, in Brave versus Ford, what is stated about this principle of unauthorized profits by fiduciaries. So let's look at what Lord Ashiel say. It stated it is an inflexible rule of a court of equity that a person in fiduciary position is not on or is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and duty conflicts. So you can see, so any person who is a fiduciary is in a fiduciary position. It is an inflexible rule. Equity don't play with it. It is a very rigid, in this sense, equity is as rigid as common law when it comes to this, that if you are a fiduciary and you are trying to make a profit from your position as a fiduciary, you will not be allowed to do so. You are trying to put yourself in a situation of conflict of interest, that your interest is now conflicting, is now in conflict with your duty, with your position. Equity need a greater one. So it's an inflexible rule. Equity will not allow you. Now, example of case where this trust was applied. It was applied in a case of renewal of lease. So you can have a heading as renewal of lease. It has been applied in renewal of lease case. And we have the case of Kitch versus Sanford. Kitch versus Sanford, and the case of Marcus or Marquis versus Edimati. So those are the two cases in which it was this principle was applied. Let's see one of them. In Kitch versus Sanford, yeah, the defendant was express trustee of the lease of a market for an infant. On the expiration of the lease, the defendant asked the lessor for a renewal on behalf of the infant. This the lessor refused to do, since the infant, because of his contractual incapacity, could not enter into usual covenants. The lessor, however, had no objection to a renewal in favor of the defendant personally, whereupon the latter took a renewal on his own behalf. It was held that the defendant was a constructive trustee of the new lease for the infant. So in this case now, the defendant was actually an express trustee for a particular infant until the of a market, a particular market for an infant, until the lease expire. When the defendant attempted to renew the lease for the infant whom he was holding the property on trust for, it was refused because of the incapacity of the infant, the fact that the infant cannot make some covenants. So it was the lessor refused to renew the lease, but the defendant now asks for the lease to be renewed for him personally, and the lessor did not object. The lessor agreed, and the defendant took the lease personally for himself. Now the law hold him to be a constructive trustee for the infant, that he was holding the lease property on trust for the infant. So you can see how the law here did not allow the defendant to take advantage of his position. So the law has declared him as a trustee. It is a similar thing that happened in that case of Marquis versus Edimati. Here the plaintiff father had been a lessee of a plot of crown land at Warri. So that happened at Warri when the plaintiff's father died. The plaintiff was an infant. After the death of the plaintiff's father, the commissioner of land continued to accept rent from the plaintiff's uncle and subsequently granted a new lease to the uncle. It was held that after the death of the plaintiff's father, wife became a trustee of the new lease for the benefit of the plaintiff. So the plaintiff father was a lessee, was a tenant of a property. When he died, it was the uncle that was paying the rents. However, the court did not allow him to enjoy the benefit of the property or to take the benefit to himself, but the court declared that he was holding the lease. He was a constructive trustee of that lease right from the time that the plaintiff's father died, because when the plaintiff's father died, the plaintiff was an infant. Perhaps it was when he attained majority that he now brought the action for the court to declare that the plaintiff was holding the property on trust as a constructive trustee for him. So you see how people take benefit of the principle or the doctrine of constructive trusts, and it was held in favor of the plaintiff. Finally, in applying this principle, a solicitor to a trust was held accountable. Finally, in applying this principle, a solicitor was made accountable for the profits made by him through making use of the exclusive knowledge gained by him in course of his employment, and that was in the case of Boardman versus Phipps. So in that case, a solicitor took advantage of his position as a solicitor for a trustee, and he made some profits. By use of the knowledge he gained, the information he gained by being a solicitor of a trust. And the court held that he will account for benefiting from that position. So the essence of a trust, a constructive trust, is usually to make people account for unauthorized profit, for unjustifiable profit, for unjust enrichment. You'll be made to account. So don't worry, it will account to you if it's taking unauthorized profits of your property. If you have not subscribed, please don't forget to do so. So later, subsequently, the discussion shall continue with other areas where this trust is applied. Thank you, and see you then.